In the earlier module, we discussed about the various roles involved in data governance. At the root of this overall regulation is the user or the data subject whose personal data or sensitive data is to be protected. One of the aspects of GDPR that has significant changes made to the regulations is in the area of data subjects' fundamental rights. In this module, let us understand what are those rights and how does it impact a user who logs into a website to share personal information. And how much control does the new law give the end user in ensuring their details are managed judiciously and are not misused. The key points here are directed at the data controller and data processors who gather user details. Let us say, a user accessed a website to book flight tickets, thereby making it inevitable to share personal details such as name, age, address, credit card details, travel plan, etc. The travel's booking website has to clearly explain it to the end user before accepting their details, whether user details are being shared with third parties such as insurance company or a hotel booking website. GDPR makes it mandatory that user clearly understands what he or she is signing up for. Under no circumstances, a website collecting user information is allowed to share or sell the data to third party without the clear consent of the user. This objective has been stated with appropriate consent to be taken from users, such as individuals must opt in by choice if they are okay with their personal data being used. User must be made aware that their data is being retained by the company and may use it for other purposes such as marketing or consumer analysis. The terms and conditions must be easy to read and understand before they click the I agree button. At any time, the user is no more interested to allow the website such as travel booking to retain the information. There must be a provision to opt out. As it has become quite common for young users below the age of 16 also have access to internet, it is of prime necessity to secure them. Therefore, any data about children under 16 required parental consent. In the recent time, we are seeing changes made by companies such as WhatsApp that has made minimum age to be 16 to use the application. The only next concern is that children shouldn't end up entering fake age to get access to restricted applications. That, clearly, is the responsibility of the parents. GDPR had clearly stated the rights of the data subjects. And here we can see those specific. The data subject's right of access, which means 1, the right to know whether data concerning him or her are being processed, and 2, if so, access it with loads of additional stipulations. GDPR Article 15. The data subject's right to rectification. When personal data are inaccurate, then controllers need to correct them. Indeed, GDPR Article 16. The previously mentioned right to erasure or right to be forgotten with additional stipulations, among others if personal data has been made public. GDPR Article 17. The data subject right to restriction of processing. Simply said, the right of the consumer, or whatever you call the natural person under the scope of the GDPR, to limit the processing of his, her personal data with, once more, several rules and exceptions of course. GDPR Article 18. The right to be informed. Here we stretch it a bit. In general, the GDPR asks controllers and so on to inform data subjects on several matters. Providing clear and correct information is a key duty in many regards. Simply said, the GDPR wants consumers to know, because if you don't know you can't decide, right? However, here we rather mean GDPR Article 19, which, again simply put, means that personal data that have undergone an action as a consequence of one of the other, just mentioned data subject rights, the controller must inform recipients who got these data, where feasible. And then the data subject also has a right, even if not strictly called a right, to ask who are all these recipients who got to see my data. So, right or not? It explains why we said 7.5, but it really is a right. More about information duties further below. The right to data portability. This is again one of those data subject rights that are in the infographic and which we covered more in depth previously. with the right to data portability we're in GDPR Article 20, so, keeping in mind that data subject rights are covered in Articles 5 until 22, that means 2 more to go. GDPR Article 21 is all about the data subject's right to object. That does indeed mean what it says. Data subjects can say they don't want the personal data processing to be done or going on. This might seem a bit overlapping with other data subject rights, but it isn't. Of course, in practice the data subject can, again within specific conditions, exercise the right to object and the right to be forgotten. Especially direct marketers and people who do profiling should pay a lot of attention to the right to object, as it's a lot about them, and certainly profiling with automated means, though not solely. The data subject right not to be subject to a decision based solely on automated processing, including profiling, which produces legal effects concerning him or her or similarly significantly affects him or her. As mentioned in the introduction video, the Internet Usage Directives laid out by European Commission did make rules since the advent of Internet in the mid-90s. However, with the new generation World Wide Web that has become part and parcel of life, it is pertinent to match the rules to today's time. If you are a Facebook user, you may have come across this feature already that allows you to download all the posts, pictures and photos that you uploaded to Facebook. This is an integral part of GDPR requirement to allow individuals to get access to their own data that they may have shared over a period of time. And it is also made very clear that websites cannot charge any fee to allow users to download their own data. Well, that sounds obvious, isn't it? I would delete Facebook account without a second thought. The data, Facebook asks money to download my own photos from its website. Duh. Individuals will continue to have the right to obtain access to their personal data. Should there be any concern that is raised by the user with a data controller or processing organization, the time to respond has been reduced to 1 month and the mandated information to be provided has expanded. So, as an organization working with EU citizen data and to be compliant with GDPR, you have to be clear about questions like 1. What's our privacy notice that is currently in use? 2. How do we obtain and record consents? 3. How do we deal with withdrawn consents? Which in turn needs a clear action plan to ensure specific consents for each activity taken from user. It is of utmost importance to update how you manage consents taken. Refresh existing consents from ambiguous multi-page, multi-paragraph notices to clear and concise statements. Keep evidence of consents and withdrawals during the lifetime of user data being retained. Apparently, get you content writer to refresh privacy notice in user-friendly language. Thank you for your time learning from our training video. Hope you found it useful. You may now proceed to the next module.